Broadcasting on StarWorldWideNetworks.com. It's time for the Cannabis Reporter Radio Show with Snowden Bishop. Listen in as Snowden interviews cannabis industry pioneers, marijuana experts, policymakers, medical practitioners, patients, and other amazing individuals with compelling stories to share. It all happens right now. Here's the Cannabis Reporter, Snowden Bishop.
Hi, and thank you for joining us for another episode of the Cannabis Reporter Radio Show. I'm your host, Snowden Bishop. As a journalist, I'm not a proponent of conspiracy theories. But when it comes to prohibition of marijuana, a conspiracy of monumental proportions seems obvious to anyone that knows the history of reefer madness and the subsequent scheduling of cannabis. By the time Congress passed the Controlled Substances Act, marijuana had been demonized to the point that no one seemed to care it was lumped into a class of Schedule I drugs. That means marijuana was in a class with drugs like heroin, LSD, and other drugs with no known medical use and a high potential for abuse. Despite the overwhelming evidence that marijuana has medical value and is far safer than other drugs, Congress has refused to acknowledge the truth for reasons no one seems to know. But now that the cat's out of the bag, states are taking matters into their own hands. More than 80% of Americans now have legal access to medical marijuana for some of the most debilitating conditions that qualify. While that's great for people with qualifying conditions, there are still too many people who need cannabis but can't get it because their conditions don't qualify, their employers won't permit it, or they'd lose benefits. Just the other day, I read a story in the news about a veteran who lost his VA benefits and was refused treatment because a routine blood screening showed he was positive for THC. This seems to be an ongoing issue with the VA. Even if use of medical marijuana would have no impact on the need for, say, a prosthetic limb or other medical services, a veteran can be denied medical benefits just because he's chosen to medicate with cannabis. When I read stories like this, it infuriates me. On this show, we've spoken to several veterans who claim with utmost certainty that cannabis has saved their lives. So why would use of a life-saving treatment bar them from receiving additional care? But that's not all. Most states require medical marijuana patients to register for a license to have access to dispensaries and to be able to purchase their medicine. In some states, patients who register for a medical marijuana license are automatically subjected to unfair discrimination and stripped of a fundamental constitutional right, the right to bear arms. Well, that's the topic of today's show, and something our guest is trying to change. But first, Dr. Brian Donner has our Medical Marijuana Minute. What do you have for us today, Dr. Donner?
Thank you, Snowden. I don't ordinarily get political, but I'd be remiss if I didn't address the announcement of an imminent crackdown on states that have legalized marijuana. While medical marijuana laws would likely not be targeted, any federal interference with state laws could have far-reaching implications for patients and medical cannabis in general. It could also have a negative effect on doctors who may have considered integrating medical cannabis into their practice. From a medical perspective, this is troubling for a number of reasons. First, we have made significant progress with efforts to educate doctors on medical cannabis and the endocannabinoid system. Many are beginning to acknowledge the scientific evidence that medical marijuana is a safe and effective treatment option. But the threat of losing their DEA licenses is enough to deter any doctor from embracing medical cannabis, and we have already seen this happen in certain states. Secondly, existing medical marijuana laws don't go far enough to qualify all of the medical conditions that could potentially be treated with medical cannabis, and they vary greatly from state to state. For example, we have some evidence that medical cannabis can potentially help to prevent suicide and curb the anxiety associated with PTSD. And yet, only a handful of states listed as a qualifying condition, and veterans could potentially lose their federal VA benefits if they use. Reversing legislation could not only potentially restrict the number of qualifying conditions, it could also create unnecessary barriers to access and make it less affordable to patients. Last but not least, the federal crackdown could also seriously dampen efforts to pass similar laws in states where medical marijuana isn't yet legal. As a Schedule I controlled substance, marijuana is deemed by the federal government to have no known medical use or utility. As a physician who has personally witnessed positive outcomes of treating patients with medical cannabis, and with the scientific understanding of the endocannabinoid system that we already have, I can say with certainty that this is most definitely false. Not only has science proven that cannabis has legitimate medical use, we now have evidence that it has a much lower potential for abuse than alcohol and other legal drugs that are commonplace in modern medicine. In my opinion, patients shouldn't have to risk going to jail in order to get the medical relief they need. Doctors shouldn't have to risk their jobs or their licenses either. Whether medical marijuana has helped you, or if you believe patients in any state should have access to it, I encourage you to write to your senators and representatives and urge them to consider sensible marijuana law reform. With a majority of Americans in favor of full access to medical marijuana for any condition, eventually federal lawmakers will have to comply with the will of the people. I'm Dr. Brian Donner for the Cannabis Reporter. I'll be back again next week with another Medical Marijuana Minute. Back to you, Snowden.
Thank you so much, Dr. Donner. Let's get started. I am really excited to introduce our guest. Robert Reed is a well-known disabled Navy veteran who's been politically active in Arkansas for well over a decade. He has held the office of vice and state chair of the Arizona Libertarian Party and was a candidate for the Arkansas House of Representatives in that party in 2016. He was the first registered citizen to become a cannabis lobbyist in Arkansas. He's a spokesperson for the Arkansas for Medical Cannabis and author of the legislative measures which passed in the 2016 elections. He's a former radio host of Cannabis News and Information radio program that aired weekly for almost 2 years on KABF in Little Rock. And if that's not enough, Robert Reed has filed a lawsuit in Arkansas that poses a constitutional question, challenging the right of the government to strip medical marijuana patients of their rights, and to question the constitutionality of whether cannabis prohibition is constitutional in the first place. Thank you for your service, sir, and thank you so much for being here. I'm so glad you could join us today.
Well, it's an extreme pleasure. Your introduction sort of hit home.
Well, I'm glad it did. I did a lot of reading about you, as you can probably tell, but you actually sent out a press release, and it was all about this court case that you filed. It's a constitutional question, not to be confused with a lawsuit that would say sue the state for money. Can you tell me a little bit about the court case?
Okay, well first a couple clarifications. All my work has been in Arkansas, and the 2016 was not mine. I did a 2012 and 2014 that did not get on the ballot. Just to clarify, because facts are facts. But here's getting to the court case that I filed in November last year. Here's the difference. All of the court legislation, and you hear about somebody went to court because they got arrested or whatever, is called a challenge to the law. So the attorney is trying to challenge, for the benefit of their client, the validity of the law. What I have posed and filed is the only ever that we can find, and this is by Westlaw, by by Berkeley University, and by the Westlaw Library, the only ever constitutional question. Now, here's the difference. A constitutional question actually questions the court, is a law constitutional, before anyone is harmed. So, see, I haven't violated any laws. I haven't been arrested. But knowing full well, if I want to exercise what I believe are my rights, and I go out here and plant a cannabis plant, I will be arrested. I will lose my benefits. I'll lose my property, lose my livelihood. Is that constitutional? So, as far as we can tell, and I've had 3 attorneys research this, this is the only case ever where a citizen is charged or questioned, not challenged, questioned the constitutionality of a state statute.
Right, and the state statutes that you're questioning involve the Second Amendment rights as well, correct?
Exactly. Well, see, what I've done, instead of going, I'm doing this out of my own pocket. So instead of going to the federal courts and going to that stuff, we'll just leave it there. I, as a citizen, have precedent or standing to file in my local jurisdiction. In other words, in my local circuit court. So I'm challenging the state statute because all the state statutes follow federal law. So my evidence is that the state follows federal law, and federal law is unconstitutional, therefore the state laws are unconstitutional, and you cannot enforce them on me.
Right. And so the unconstitutionality would have to do with whether or not cannabis should even be considered in the Schedule 1 of the Controlled Substances Act. Is that part of it?
Well, that's part of it, but here's the devil in the details. Marijuana, under Title 21 of the U.S. Code, is a Schedule 1 drug. And all reporters report that marijuana is illegal under federal law. What they fail to report, cannabis has never, is not, and has currently never been listed on the Controlled Substance Act. So how can the cannabis plant that I grow for purpose A, B, or C be illegal under federal law when under federal law it's not listed?
And that would be something that most people wouldn't know.
Exactly. And again, it's just like our presidency and our laws and our media, and I use the media term lightly because you are in the media, and so am I, because I've done, radio show for a couple of years. The devil's in the details and devil's in the truth. Here's the fact, and anybody can go to my website. TCNP is Talk Cannabis and Politics, and there's several ways to get to it. TCNP, TCNP. But anyways, under the federal definition since prior to the Marijuana Tax Act, the word marijuana has a black and white federal definition. And under the black and white federal definition, the word marijuana is defined as, and I quote, cannabis sativa L, end quote. That means marijuana, by definition, by the federal government, is only one, and I repeat, only one out of the 700 and some cannabis plants that are illegal.
Right. So in other words, a cannabis indica of hemp variety is not technically.
It's not covered. The rudialis, any strain other than cannabis sativa L, cannabis sativa M, J, 6, 4, 5, 6, all the indicas and all the rudialises, not a single one of them will you find listed in any federal statute under Title 21.
Right. Although extracts of any one of those that would contain THC or now more recently CBD would have its own numerical code under Schedule 1.
Well, and that's, again, that was in the details. The new rule that came out and went into effect in January labels any compound from any plant containing CBDs of any amount as a Schedule 1.
Yeah, a single CBD of any amount.
A single CBD of any amount. Now, what the DEA and the government and even our state is not recognizing is the courts have overturned, I believe the Ninth Circuit overturned, that the THC Delta 9, what everybody calls THC, all right, was referenced as synthetic, not natural occurring. Well, if it's in the plant, it's natural occurring. Synthetic is Marinol, which
right.
is, by the way, 100% synthetic Delta 9, and it's a Class 3 narcotic.
Right, which is crazy because there are side effects to that.
And not only that, the Marinol at my local drugstore down here at Walmart, if they can get it at any Walmart, they just got to order it because it's so expensive, don't keep it. Last time we checked, which was about a year ago, was 2,610% more expensive than the best medical grade in California.
Right.
And it's only one compound.
Right. And it's synthetic.
And it's synthetic. So, 3 strikes, you're out. But see, it's legal because it's a synthetic pharmaceutically